I'm supervising Special Agent Dr. David Lee, and Dr. Fields has asked me to explain the crime of Penal Code Section 237A, false imprisonment, to your class. Let's start with misdemeanor false imprisonment. The jury instructions with the elements of this crime are found in Calcrim 1242. To prove that the defendant is guilty of this crime, the people must prove that 1. The defendant intentionally and unlawfully restrained or detained or confined a person. And 2. The defendant's act made that person stay or go somewhere against that person's will. An act is done against a person's will if that person does not consent to the act. In order to consent, a person must act freely and voluntarily and know the nature of the act. False imprisonment does not require that the person restrained or detained be confined in jail or prison. Examples of misdemeanor false imprisonment include blocking an exit to a parking garage and refusing to let someone exit, grabbing your spouse by the arm during an argument and preventing them from leaving, locking your girlfriend in your car and refusing to let her get out. If the defendant claims they had a legal right to restrain, detain, confine a person, the court will need to further define for the jury when a restraint, detention, or confinement is legal. For example, a police officer may be charged with false imprisonment if they arrest a person without probable cause or a warrant. A parent who confines his or her child with the intent to endanger the health and safety of the child or for an unlawful purpose can be prosecuted for false imprisonment. People v. Checketts, 1999. If there is sufficient evidence that the parent's restraint or confinement was a reasonable exercise of parental authority, the court has a sua sponte duty to instruct on that defense. Now let's discuss felony false imprisonment. If the defendant uses violence or menace during a false imprisonment, the crime can be charged as a felony. As explained in the jury instructions, Calcrim 1240, to prove that the defendant is guilty of felony false imprisonment, the people must prove that 1. The defendant intentionally and unlawfully restrained or confined or detained someone or caused that person to be restrained, confined, detained by violence or menace. And 2. The defendant made the other person stay or go somewhere against that person's will. Violence means using physical force that is greater than the force reasonably necessary to restrain someone. Menace means a verbal or physical threat of harm, including use of a deadly weapon. The threat of harm may be express or implied. For example, the defendant waves a baseball bat at the victim during false imprisonment. If the defendant is accused with false imprisonment for purposes of protection from arrest or use as a shield, this is a violation of Penal Code Section 210.5. Refer to Calcrim 1241, false imprisonment, hostage, for the elements of that crime. False imprisonment of an elder or dependent adult by use of violence, menace, fraud, or deceit increases the penalties for this crime. An elder is any person who is 65 years of age or older, as defined by Penal Code, Section 368G. A dependent adult is any person between the ages of 18 and 64, with specified physical or mental limitations as defined in Penal Code Section 368H. Defense lawyers draw upon several defense strategies to contest false imprisonment charges. These include showing you had the legal authority to restrain the alleged victim, such as making an arrest, which is covered in depth in a different lesson. The victim consented to the imprisonment, or you were acting in self-defense. You were exercising your parental rights. The shopkeeper's privilege applies. Under California law, the principle of shopkeeper's privilege permits shopkeepers, store owners, or merchants to detain a customer if they have probable cause that the person is guilty of shoplifting per Penal Code 459.5. I'm SSA Dr. David Lee, and that is your lesson on false imprisonment.